have Ms. Emily name, knowing that this information is super complex, but you present it in a very approachable way. So we really thank you for donating your time to be with us and share about special needs planning.
Sure.
Thank you very much.
So thank you all for coming. I hope if you have questions, you'll ask them. It makes it more interesting for me, makes it more interesting for you. I'm sure if you have the question, somebody else in the room who doesn't want to put their hand up probably has the same question. I just ask that you make sure that your questions are kind of general. Don't tell everybody your personal information, and I will try to answer them in a general manner. So we have offices in Sun City and in Scottsdale. And I've been practicing since '93, so 30 something years, I think, which makes me feel super over the hill. And I do a lot of special needs planning in lots of different areas. Sometimes I'm consulting with other attorneys who are doing estate planning and don't know about special needs trusts, or they're concerned that they're going to do something that will make it so that the kids who are on benefits are going to lose those benefits. We work with personal injury attorneys when somebody gets squished and now they have money that's going to come in on a settlement. What do we do with that? We work with family law attorneys when there's going to be a divorce and either one of those people or they have kids who might need child support, but they're on SSI, and kind of what's the interplay to make sure they can maximize benefits. So sort of the whole broad array plus regular plain old estate planning. So unfortunately, Matt Gobatto, who's one of the other partners in the firm, has pneumonia. So he is on the second round of antibiotics, and I talked to him today and he does not sound like a heavy smoker anymore. So he doesn't smoke at all. He doesn't sound like a heavy smoker anymore. So I know he's making progress. So I just want to remind you all that even if I represent you in real life, for purposes of today, just consider that it's not attorney-client privileged, and just make sure you're, again, answering questions, asking questions in a general fashion, and understand that for the most part, I need a lot more information to actually answer the question. So I'll do my best, but I do encourage you to ask me questions. So we have a lot to cover. We have plenty of time, and we'll either end early or we'll end on time, depending on how things go. So these are the topics we're going to talk about today. Guardianship, supported decision-making, SSI and other benefits, special needs trust, and ABLE accounts. So we're going to start with guardianship. So usually people say, well, wait a second, you just put up your first slide as a conservatorship, but we were going to talk about guardianship. So guardianship is making health, housing, and education decisions for a person who is incapacitated or sometimes a minor. If you go to do the guardianship on your own, or you hear other people talking, you might think, well, I need to do a conservatorship also. And so you only need to do a conservatorship, which is a court process, in the event that there is money that needs to be managed for that individual. So that means that it's not just their Social Security benefits, because if you're the representative payee for Social Security, you don't need a conservatorship. You already are reporting to Social Security, so you don't need the court to appoint you for some purpose. If the money is going into a trust, you don't need a conservatorship over that person, because the trustee will manage the money that's in the trust. So conservatorships are only required if there's going to be money that needs to be managed and we don't already have you in a role where you can manage it. So, for example, maybe somebody was okay and then a bad thing happened to them, and they have a bunch of money, they have an IRA, they have maybe a bank account, and they don't have any estate planning documents where there's a financial power of attorney that would allow that money to be managed by somebody. And so we have a bank account, but nobody can access it to pay their bills. That's when we need to do a conservatorship. So don't feel like you have to do it. Don't just throw it in for the just in case, because it's a huge deal and you only want to file with the court for the things that you actually need. Please. Sure.
Is that kind of like a post-nuptial for marriage? Like you didn't put a trust together and we don't have a guardianship. So now, but like said, now something has happened. And so we're covering the conservatorship after the fact.
Yes. So again, conservatorship is only about money, and it's only when we don't have a different way to manage it. So if it's in a joint account, usually the joint account owner can manage those funds. If it's in a trust, the trustee can manage those funds. If they did an estate plan and they have a financial power of attorney, usually the agent under that attorney can manage those funds. But sometimes we have people where we don't have any of that. So then after the fact, we have to go to court and say, hey, by the way, this person is entitled to money, or they have money, but there's nobody to manage it for them. So I need to be appointed so I can do that. Yeah. So guardianship is the process of getting appointed by the court for the purpose of making decisions for the person. And in some ways, it takes away their ability to make their own choices. But the goal of guardianship is to allow the person to be as independent as they can, to strive for them to be able to make decisions and to listen to what their wishes and goals are. So even though, yes, it can take away their rights, your goal is still to do what's in the best interest of that person and to give them as much autonomy as you can. And so the statute talks about that the guardian is basically in the same role as a parent is to a minor child. That's exactly what's in the statute. So one of the questions that people sometimes have is, am I then liable in the event that the person that I'm in for gets in a car accident or does a bad thing? So you are not, unless you were grossly negligent. So if that person doesn't have a driver's license and you give them the keys to the car and say, hey, can you just run out to the grocery store and pick this up for me? And they get in an accident and you're their guardian, you might have some liability there because they don't have a driver's license and yet you help them do something that then put them in a bad situation. If they sign an agreement with somebody that they're gonna pay, they sign a credit cards, to sign up for a credit card or whatever it might be. That doesn't, you're not liable when they don't have the money to pay. That's their credit card, that's on their credit. You don't have any liability for that. But guardianship is a big deal. We have to have a hearing for every single guardianship, which I understand in some states is not the case. Sometimes people can just submit a bunch of papers to the court and then they don't have to have a hearing. All of our hearings are remote, no matter what county you're in. You may have to ask in some of the mountain communities to do them remote, but we practice in all of the counties. And sometimes it's by phone, sometimes it's by Zoom, sometimes they have their own system and you click on the judge's name and their profile and that gets you into the hearing. When you file, you get something called a notice of hearing, and that provides the link for the phone number to call into the court. But they're all remote, which I think has been really a positive for most clients, that they don't have to leave their loved one at home that might need care or leave their job. The hearings usually last about 15 minutes. They're not, 3 hours long, unless there's an objection. For the attorneys, it makes me kind of sad because I don't get to see my colleagues all the time, whereas I used to see them in the hallways at court and see their proceedings go on, but that's how it works. So when you become the guardian, you have to file an annual report each year, which is it's a couple pages and it's a check the box. And so that is for you to say whether they're on benefits now. How often have you seen them? Have there been any major changes? All of that goes on the annual report, and there's a new health professionals report that has to be filed each year. That can be completed by a registered nurse or a DO or an MD. So most people in your sort of circumstances are looking at guardianship when their kid turns 17 and a half, so that it will be effective on the 18th birthday for that child. There's no have to. If you wait till they're 18, that's fine. If you wait till they're 25, that's fine. But you can't file before they reach 17 years and 6 months for it to be effective on their 18th birthday. And so hearings usually they usually get scheduled about 45 to 60 days from the time you file. It is not an emergency because you forgot to file your guardianship. So you're like, oh my gosh, my kiddo is turning 18 tomorrow. You don't get to file with the court and say, there's an emergency because I'm late. Unless there's an emergency, right? You have some kind of health crisis and there's nobody to approve that treatment. In that instance, you can file for an emergency guardianship because we need to get you appointed right now in order to take care of that person. So again, as I said before, the goal is to always look out for the best interest of the person that's gonna be under the guardianship. So sometimes clients ask me, do you think my kid needs a guardian? I'm like, I've never actually met your child. So I don't know if they need a guardian, or I haven't met your dad who has dementia. So the court is gonna look for a health professionals report. That's the document that explains, are they incapacitated? Are they able to make decisions on their own, or will they be able to do that when they turn 18? I'm hopeful that you're talking to the teachers in the school system and their doctor, whoever they see for therapies or whatever's going on, maybe your DDD support coordinator, about like, where's my kid on the axis of gonna be able to make these kinds of decisions. One of the other things to remember is that we call them permanent guardians, but nothing has to be permanent. So maybe as your kiddo ages, they're gonna be better decision makers. Maybe they're gonna mature and be able to be responsible and make choices for themselves. So if you become their guardian and then they don't need a guardian anymore, because we have a physician report that says they don't need it any longer, we can go back to court and we can terminate the guardianship. So still a hearing, still have to submit a bunch of papers, but they are only able to be terminated by the court. I can't just say, oh yeah, it looks great. Let's just get rid of that guardianship. Yes, sir.
Don't they expire at a certain point?
So,
We just run out the clock on that year's contract and.
so they don't expire. So unless you do something, they remain in place. If you have inpatient mental health authority because your person needs to be potentially hospitalized in a behavioral health center, that is only good for 12 months. And so every 12 months, you have to file a new report from a psychologist or psychiatrist and provide the evidence that in fact that person is gonna need that continuing, you're gonna have that continuing responsibility. If you don't file your annual reports, eventually the court is gonna send you what I call a nastygram. They're gonna say, hey, you didn't give us an annual report. We sent you a notice. You still didn't file your annual report. I don't have a health professionals report. And they can actually have you picked up by the police or the sheriff or whatever is in your community. Because that is a red flag for the court to say the guardian is not completing their responsibilities. I'm concerned about the welfare of this kid. The court can also send out a court investigator, which will always happen in every guardianship at the beginning. But if you aren't filing your reports, they may send the court investigator out to make sure that the person is safe. But they don't terminate, they don't have an expiration unless you are temporary guardian. So sometimes we have a temporary event and the person is gonna get better. And so we say, this person had whatever, a stroke, whatever it was, we just want temporary guardianship. Let's give it 6 months and see how they're doing, and then we can come back and terminate it again. But otherwise, there's no expiration of the guardianships. So the guardianship, again, is for medical decisions, housing decisions, education decisions, all the decisions that you would make, again, a parent to a minor child, including consent to marriage, and adoption. If you are doing, if you are guardian and you want to do any kind of surgical procedure so that the person doesn't have children in the future, we typically have to go back to court to get that authority because most of the time that's irreversible. And so we want a court order that says, this is what we're going to do because people change, technology changes. We don't know what's on the horizon for people in terms of what treatment may or may not be available. So there's a lot of paperwork and probate, most of the other courts, the other divisions within the Superior Court, you can file things electronically, but you can't do that in our lovely probate division. So we are hopeful, maybe next year, that we'll be able to do that. But right now, it is literally a stack of paper. So the court website has all of the documents. They also have procedures. Tells you how many copies you have to drop off, who has to get the copies, what you have to do, which piece of paper to file first. So you certainly can do a guardianship on your own. You just have to make sure you follow the rules exactly the way they're laid out in that procedure. If you miss a step and you get to your hearing and you didn't do something, the court may just continue the matter until you do whatever that thing was. There are also some nice things that happen now, which is it used to be that you had some extra forms to fill out and you had to make some more requests. But now the court does a lot more for you automatically. So that's terrific. That's super, super helpful. One of the things about a guardianship is that you have to notify the parent unless their parental rights have been terminated. So if you are divorced and you cannot stand your former spouse and they haven't seen their kiddo for 18 years and they don't pay child support, that person is still entitled to notice of the guardianship. So unless their rights have been terminated, the statute says parents and adult children are entitled to notice. So most of your kids don't have adult kids, but guardianship rules are basically the same whether you're 99 with dementia or you're 18 and you have autism. Same rules, other than we can file sooner, 17 and a half for the kids. So just be conscientious of that. Also, if you are divorced and there was a child custody order, we have to attach that to the petition. So the court understands if you're divorced, did somebody have all the decision-making authority? Are there concerns about this person? If you have an order of protection against the other parent, in that instance, you can ask to waive service for safety reasons. So there are some exceptions, but for the most part, you have to provide notice to the other. So I said we have court investigators. So those are court staff. And so they're going to call and say, I am from, usually they say I'm from the probate administration office. And they will come out to your house or they'll do a FaceTime or something else. Their job is to put eyes on the person that we're petitioning for guardianship for and talk to the people who want to be the guardians. Usually they want to see, like, where's their room? Is it a safe place? The person, you know, look like they're well fed and they seem clean and tidy and not afraid. And so that is true for all guardianships. So it doesn't matter if your kiddo is not verbal. It doesn't matter if the person's in a coma. It doesn't make any difference. If you file for guardianship, there's going to be a court investigator. They provide a report to the court. It usually doesn't get filed until about a week, maybe 2 weeks before the actual hearing. Be really conscientious when you talk to the court investigator because they don't edit typically what you say. So if you say, my kid's kind of a pain, but I really like them and I want to be the guardian for this person and blah, blah, blah. It's probably going to say something in the court report about the person expressed concerns about their relationship with their kid, but they're still willing to be the guardian. If you say my ex-spouse, the dad of this kid is a deadbeat and they don't pay the child support and they're horrible, it's probably going to show up in the court investigative report. So be truthful, but remember that somebody's going to read it, which is everybody. The court's going to read it. I'm going to see it. Your attorney's going to see it. And the court also is going to appoint an attorney for your kiddo. Again, it doesn't make any difference if they're nonverbal or they're in a coma. Every single guardianship in the state of Arizona, there's going to be court-appointed counsel. And no, you can't pick that person. There's a list of people who have been vetted by the court system, and they get randomly assigned to be the court-appointed counsel. Their job is to hear what the person who's going to have a guardian says. Do you want your mom to be your guardian? Do you not want your mom? Do you rather your sister? Whatever it might be. And so they're going to advocate. They're not there to serve the best interests of your kid. They're to be an advocate for your child. They're their attorney. So just because your kiddo objects doesn't mean you lose. It just means we might need some more evidence in another hearing. But they can object to the guardianship. And they're also supposed to explain what the petition is about. What is it? So as I said, we need a health professionals report. So there's court forms for that. So it's pretty easy for the doctors to fill it out. Sometimes the doctors are going to charge a fee. So you might want to ask in advance, is there going to be a cost for this? So you're not surprised later. And that health professionals report is because the court's really familiar with it. It's a check the box kind of a thing. Where should they live? What's their diagnosis? What medications are they on? Kind of goes through all of that. And Also on that report, you can have a guardianship and your person can still retain the right to vote and or the right to drive. That health professionals report, there's a place for the doctor, the health professional, to write notes about, check the yes or no box, but then explain. So if you have somebody who can't vote because they're not going to understand a ballot and they're not going to understand that they're voting for a position within politics, the doctor might write notes about that they wouldn't be able to understand a ballot that's beyond their comprehension. The same thing for driving. We usually suggest if you want your child to be able to get a driver's license, if they don't have it already, that you have them go to one of the schools that will do that, so they can take a test, so we can attach the report that says they can drive. They have the physical and psychological ability to do that. We did testing. Usually those are on what is that called? Simulator. And so they're not out on the road. If your kiddo already has a driver's license, we just want to attach a copy so that the court is aware they already have a license. If they don't, and it wouldn't be safe, again, we just need the doctor to fill out that part of it to say it would not be appropriate for this person to obtain a driver's license. If later on they want a driver's license and they can, again, pass a test, we can go back and give them their driving privileges. So nothing is forever, unless it is, but it can be changed, is my point. It doesn't have to be forever. As I said, there's going to be a court hearing. They're all virtual. Please make sure you're in a quiet space when you do them. Make sure that your audio works and your video works beforehand. You can test out the link before the hearing starts, anytime after 5 o'clock or on a weekend, because the court is not open at those times. So you can try it beforehand once you get your notice. So those are all my tips. I actually took screenshots recently of what the screens look like because there's no real instructions. And so it's a Microsoft Teams based product, but it's not like the Teams you use at work at all. So the functionality is a little bit different, and you don't have to have Teams in order for it to work. You can also just do it by phone, but the commissioners really like to see everybody, and they really like to see your kids. They're making a big decision. And so if your kiddo can be in the video, even just at the beginning, that's great. They want to see that they're there. And then the court appointed counsel will be on the video as well. Court investigator only provides a written report. So I talked about, you can keep driver's license and voting privileges. So you can nominate a successor guardian in a separate written document or as part of your will. I really like to put it in both spots, but I really like the separate nomination of successor guardian. We don't have backup guardians through the court system. So you either have been appointed as a guardian or you're not. You can have more than one guardian. It can be you and your spouse and your oldest child. It can be just you and your spouse. It can be just you. It can be you and the child's sister or brother. So it can be their cousin. Courts routinely in the counties in Arizona will allow up to 3 guardians, but nobody is a backup. So if you're appointed, you are a guardian, you have the same rights and responsibilities as all of the other guardians. So, and they have to show up at that remote hearing in order to be a guardian. But in your will, you could say, if the bad thing happens to me, then this is who I want. And then what happens is some documents get filed with the court. If the bad thing happens to you, that person that you've nominated becomes the guardian right away. And then they go back and do the hearing and notice and all that other stuff. So they still have to go through the process just after the fact. Yes.
And if you have more than one guardian, the decisions have to be made together, or does one person make them and the other person? How does that work?
Yeah, so that's a great question about whether or not, if you have more than one guardian, do you have to all agree to everything and be at every medical appointment? You can set it up either way. So typically when we do them, we say that each person has independent authority. So mom and dad don't have to be at every IEP. They don't have to be at every doctor visit. They don't have to always be together to make decisions. But for some families, it's important to them that they do have a second opinion and they want it to always be joint. So you can do it either way. Yeah. Yes, sir.
For most trusts, you kind of have if something happens to me and the trustee and the other person, and I say, all right, I leave all this money to the SPCA. For this, what's the default if everybody's gone? who's
Yes.
supposed to be.
Sure, so the question is kind of what's the default if we haven't named anybody? So again, that nomination of successor guardian or doing that in your will is really important to try to avoid that. And those documents are completely amendable as long as you're alive and competent, right? But if we don't have anybody, then somebody has to bring it to the court's attention. So somebody's going to be filing the petition. That might be Adult Protective Services. That might be that the school system has said the parents aren't responding to anything. The kid has told me that their parents are now deceased, nobody's at home. The Maricopa County Public Fiduciary can serve in the event that we have somebody who doesn't have any assets, which is typically the situation, obviously, with a kid. And if there's no relative or friend who's willing to step up. That is the last resort, though. So if they file the petition, the Maricopa or all of the public fiduciaries for each of the counties are going to do as best they can of an investigation to try to find some relative who might have an interest. But it happens that we don't have a backup person.
Are there online questions?
Yes, there are. There's one about conservatorship. So it says that she was informed to get a conservatorship when the only money that her son receives is SSI. Does she still need to keep the conservatorship after all these years?
So I don't know how long ago that happened, but the court now would not want you to have a conservatorship when there's only Social Security money. Because you have to typically account to the Social Security Administration, and it's more administration for the court because they have to typically have a court accountant who's going to oversee those. So I would probably recommend that that person file a petition to terminate the conservatorship and explain that the only money is Social Security and provide a copy of what's called their letter of that they're the representative payee so that the court knows that they have that authority. I'm going to take this gentleman's question and see if something else pops up online. Yes, sir.
Parents with the guardianship not the sole independent status, so it can be men and men, so it's in place of female parents. It's when
So the question is, what if we have divorced parents? What happens? And so both parents have equal priority to file a petition and serve as guardian. If there is a custody order where one parent has lost their parental rights, then that is a different situation. But guardianship is not about custody. I could be guardian of my niece who lives in Boston. Guardianship is decision-making, and I could decide where my niece lives. So they're very different. The other thing about guardianship is your responsibility is the best interest of that individual. That is your sole job. So if we have divorced parents and they don't like each other, and oftentimes we have a lot of divorced parents and they might not, they definitely don't want to be married to each other, but they're fantastic in taking care of that kid and they agree and they work really well together for that child. But if we have divorced parents and the relationship is not good and they cannot communicate with each other, most likely you're going to end up in a contested guardianship where each of the parents is going to have to put on their own case to provide the testimony about why they are the better person. Understanding that the court can just appoint a third party if they think this is not going to work. They can appoint a public fiduciary if there's no money. They can appoint a licensed fiduciary if there is money for that to be paid. It also might be that those orders relate to you're the guardian, but you have to let the other parent know about changes in who the doctors are, changes in medications, whatever information needs to be provided. So at least the other parent is aware of what's happening, even if they're not the decision maker. But one parent, unless there's a termination of rights, doesn't have priority over the other parent.
so the guardianship doesn't supersede already impacted.
So the question is, so the divorce or custody order, does that override or do they have to work together with the guardianship? When you file for guardianship and there is a custody order, you have to attach it to the petition so that the probate division is aware of what happened in the family law section. Then they have to look at what's happening now. And it may be, because again, it's not about custody. So they could put something in the order about you still get them every other weekend and you get them on odd holidays or whatever. But it's about decision-making authority. Again, if one parent had sole decision-making, that person is probably going to end up as the guardian if the two of them can't work together. Because we already have a history where another judge has already determined what's in the best interest of that kid from decision-making. But they are separate matters. But sometimes you end up with the fight that happened in family law in the next section. Yes.
Can you, just a follow-up question to the conservatorship question?
Sure.
For dissolving it, is that something that she can do on her own or does she need representation? And does it hurt to keep it? Or I think you mentioned before that they would want to dissolve it.
Yeah, so it doesn't hurt to keep it. It's just whatever responsibilities you still have to the court as conservator, which you otherwise wouldn't have. Anything can be done pro per, that is without an attorney. There's never a requirement to have an attorney. It would be a petition to terminate the conservatorship if that person wanted to move forward with that.
Thank you.
So I have only one slide on supported decision making. I'm sure they exist. I haven't met the family who has a supported decision making agreement. So supported decision making was legislation that was passed 2 years ago, I think. Time runs together for me. So the idea was to try to have something in between being able to do estate planning, having a power of attorney, and going to court and that person having no authority over their own decisions. However, supported decision-making is not guardianship light. It's not like a guardianship. In fact, what it is an agreement with a person who is disabled but not incapacitated, where the adult, that's the person who's disabled but not incapacitated, signs an agreement that says, I will come to you when I have to make a decision about my health, my housing, my finances, where I'm going to go to school, whatever the decisions are that adult wants to have a decision maker for. And they then list who their supporters are. I'm going to go to mom for this. I'm going to go to dad for this. I'm going to go to my aunt for this. I'm going to go to my clergy for that, whatever it is. However, the supporter may not sign any agreements on behalf of that person. They cannot bind them to anything. They cannot speak for them. They are in the wings saying, that's a really bad idea. That's a really good idea. But they don't have the right to sign anything or make any decisions for that person. That's their whole job. And the adult, the person who is disabled but not incapacitated, can terminate it anytime they want. They can say, you know what? I don't want to listen to you anymore, Dad. That's the end of my agreement. Not only that, but they can keep the agreement in place and say, I don't really agree with you. I don't want to come to you the next time I have a question about that. Or you can voice your opinion, but I don't really care what it is. So for some individuals who are very rule oriented, this might work really well because they're like, that's the rule. I have to talk to my dad before I can give you any money, right? So that might be terrific. If the person's under guardianship, you can't do a supported decision-making agreement because they've been determined to be an incapacitated person. So just so you hear the vernacular, you understand what the words mean, what they're for, kind of what the purpose was. Does that sort of make sense? Any questions on that? There's 70 people and we've only had like 4 questions from the online. So topic number 3 is about special needs trusts. So sometimes they're called special needs trusts. Sometimes they're called special treatment trusts. Sometimes they're just called the Joe Smith Trust. The words in the title do not tell me what kind of trust it is. It could be called a special needs trust and not even meet the requirements of a special needs trust. So what matters is what's in the paper. What do the documents say so we can make sure it's going to work? So the goal of a special needs trust is to be able to leave money or that kid who gets money in a trust, so their all tax benefits, their DDD services, and potentially their SSI are not impacted. Because the money in the special needs trust, you can have $10 million in it, and it wouldn't impact SSI, DDD, or all tax benefits. So that's what its goal is, and its goal is to have money to enhance the life of that person. For you people, you folks who have kiddos who receive DDD services and all tax benefits, so the Department of Developmental Disabilities and the Arizona Long-Term Care System. Maybe you have X number of hours of therapy. Maybe you have a caregiver for this number of hours. The trust can pay for extra stuff. It can pay for more than what the state is going to cover for those benefits. So that's what its purpose is when there's money to not impact the services you're getting free, but to be able to have money for the other things that those services don't pay for. Right? Altex doesn't cover dental care. I don't know what I would do if I was on benefits because I can't see without my glasses. And typically Altex isn't going to buy new glasses for somebody. They don't buy you clothing. And again, they only provide those limited benefits. So the special needs trust, like many revocable trusts, family trusts that you may do as part of your own estate plan. In this instance, it's a barrier between the person who is on benefits and the money that's in the trust. They're not the trustee. They don't just, they get stuck at the very end, right? They need the trustee to release money in order for them to be able to access those funds. And so that's what its purpose is. And usually it has language to say the trustee should look at government benefits first. The goal is not to supplant those benefits, but it never has to say it can't pay for food or shelter. It can't pay for X. The issue is what's the impact if it pays for something, or what's the impact if we give cash to a person who's on SSI or Altex or DDD, and we give cash from the trust to them. What's the impact on their eligibility? Not that you can't do it, it just may impact what those benefits look like. So I wish we had different words that made more sense. But we have first party special needs trusts and third party special needs trusts. So first party special needs trusts are where it's the kid's money, it's the individual's money. So if I am a person who has Down syndrome and I get squished by a bus and I get a bunch of money, that's my money. It can go into a first party trust so that I can keep my benefits. Or what if I get money as an inheritance? Emily does a terrible estate plan for herself and she leaves money to her niece Marissa, who has Down syndrome. That money has to go into a first party special needs trust because that's Marissa's money. I didn't say it goes to the trustee of Marissa's trust. I just said, hey, when I die, Marissa gets this money. So those are first party trusts. Sometimes people call them, those are the payback trusts to Medicaid. And everyone's like, well, I don't want a special needs trust because I don't want to pay back to the state. But it's only these kinds of trusts that we end up with a payback. And the payback is only when the beneficiary dies. So they can use all that money during their lifetime for their benefit. It's only when they pass away that the state is going to get money back for the services that it paid for. And we have other rules like it has to be funded before the kiddo turns 65 years old. You can't add more money except for some specific exclusions. So my little example here, where Wilma's enrolled in DDD and Altex, she's getting her SSI payments each month. She lives in a group home that's paid for by Altex. And again, grandma leaves $500,000 not in the trust. And now she doesn't have SSI anymore because she's over the $2,000 asset limit. She loses her DDD and Altex benefits because she's over the $2,000 asset limit. And so the answer is now we have to put it in a first party special needs trust. Those trusts can still pay for pretty much everything that beneficiary needs. It's just that we have to do a budget that Altex has to approve. They're entitled to all the bank statements for the last 12 months that's related to that trust. And again, when the beneficiary dies, they say you can't touch any money in that trust until we get our money back. So if your kiddo had $1 million worth of services and there's $20 in the trust, they get $20 and that's the end. They don't get your money, they don't get anybody else's money. If they are owed $1 million and there's $2 million in the trust, the state's gonna get the first million and the other million's gonna go to whoever the beneficiaries of the trust are. So you just always have to make sure that you keep receipts and you keep all the bank statements and all of that for when you do your all tax renewal. If there's a trust, then they're gonna want all those statements. So third-party trusts, those are the kind that are part of your estate plan. That's what every single person who has a kiddo who's on benefits should have as part of their plan. That's the way that Emily can leave money for Marissa and not mess up her benefits and not have a payback requirement at that. That's not gonna be required because it's just part of my estate plan. I could have just left her out. I thought. And total flexibility, you don't have to do accounting for the state, there's no budget, all of that stuff. You don't have to do any of that. One thing that's really important that I want you to know is you don't tell Altex or SSI about the fact that you set up a trust for your kiddo unless it has money. The rules say it doesn't, if it doesn't own anything, you don't tell the state or the feds about it because you could revoke it. You could say, no, I'm never going to fund that. It doesn't matter. If you tell them on your renewal that you have a trust for your kid, it's really, really hard to prove a negative. They're going to say, show me the bank statements. You're say, I don't have any. All right, well, show me title to the assets that are titled to the trust. You're say, I don't have any. It just goes around and around and around. So please don't tell them if you have an estate plan and you did a special needs trust, but you didn't open a bank account and it doesn't own anything, just say no on the application. Okay, say, no, there's no trust for this person. The other thing is, if you have relatives who might want to leave something for your kiddo, make sure they know you have a special needs trust. So, like, again, I have a niece who has Down syndrome. So I did all the estate planning for the whole family. So of course I knew there was a special needs trust for her. But if not, grandma should know, hey, grandma, if you want to leave something for Marissa, I have a Marissa trust here. Auntie, if you want to leave money to Marissa, I have a special needs trust, put that in your plan. If you are the beneficiary of your parents' estate plan, it probably says generically, if you're deceased, it's going to go to your issue or your children or your descendants. Well, I don't know when the bad thing's going to happen to anybody. My crystal ball is always broken. So you would still want that plan updated to say, instead of it just goes equally to my descendants, goes equally to my descendants, but if anything's going to Marissa, it goes to the Marissa Special Needs Trust. So again, if money's going to trickle down, which we all would love, we want to make sure that we're not going to mess up any benefits for that beneficiary. So same example in my will, that was my first dog, this dog from the Flintstones. Anyway, if this was done correctly, it's the same example, only now we have a trust for Wilma. And so Wilma doesn't have to lose her benefits. We don't have to go to court. There's nothing else to happen except we open an account. Report it to Altex, report it to Social Security, and we're done. We don't have to do annual reporting for them anymore. So your estate planning special needs trust, your third party trust, it can be part of your will. It can be part of your trust, or it can be a standalone document. I personally would much prefer, as you can see underneath that thing, but it says it can be a sub-trust of the trust. I like to have a standalone special needs trust. Makes it really easy for you to name it as the beneficiary of life insurance, retirement accounts, has its own name. When you go to open the account, you don't say, oh, well, here's the 60-page trust from mom and dad who are now deceased. If you look on page 40, that's where it starts the parts about the provisions for this beneficiary who is a special needs beneficiary and is receiving benefits. It's just its own document. You go and say, here's the Marissa Special Needs Trust. So that's my preference. The last 2 times I've submitted to disclose special needs trust to Social Security, they have said it isn't a trust. It says that a trust will be created on the death of mom and dad if it was a sub-trust in the trust. And then we've drafted the trust and said, that's stupid, but with the government, you usually want the least resistance. We don't want to slow down the Social Security application. And so we just drafted a new trust that said, this is the trust that was described in mom and dad's trust, and here's our new document. You don't have to do it that way. Yes, sir.
I maybe get a little too nitpicky here. Maybe your example about the grandparents, if we were to disclaim any inheritance, and it passes on to the next heir, at that point, the third party, if it was named, the special needs trust would then be funded. But
Correct.
now there's something in play, even though we haven't deceased and it has not sprung into existence.
Absolutely. So you could have a trust that says if I'm deceased, it goes to my descendants, and you can disclaim that because you say, I don't want the money, it's gonna increase my taxes, whatever it might be. As long as it says it goes to the trust, and at that point, it has to be disclosed. 1 penny that's titled to a special needs trust has to be disclosed to any benefit programs that that person is receiving. Whenever it is that would. For sure.
Even if it's not theirs, there's that wall, you still have to.
It's a change in financial circumstances, and when you sign up for any of the benefits programs, it says if you have a change in financial circumstances as the beneficiary, you are required to report. You're supposed to report for all tax benefits 10 days after receipt, for Social Security's 10 days after the following month. So you get like an extra potentially 30 days before you have to do your report. Should always be done in writing. It should always be sent by some way that you get a receipt back that somebody signed for it at the agencies, or for Altex, you can do it through their email system now. They're terrific on their email system. So you usually get a response back. Yes, we've received this. It's been assigned to an eligibility specialist, but it has to be reported. Sometimes Altex gets it wrong and it's a third party trust, and they're going to ask for your budget, your rights and responsibilities, all your bank statements. You just have to tell them, I'm so sorry, I think there's a misunderstanding. Because it's not one of those trusts, it's one of these trusts, and I just have to tell you about it. But I don't actually have to tell you the rest because you're not the beneficiary. So however it gets spent doesn't impact your rights because you aren't the beneficiary of that. And special needs trusts can own as sophisticated or unsophisticated assets as you want. They can own houses. They can have a brokerage account, they can have a savings account, they can own CDs, they can own bonds. Whatever, they can be a member of an LLC. It only matters that it stays titled to the trust, that's all. So these are the reporting requirements that we talked about. So I think this is our last topic, is able accounts. Any questions on special needs trusts from our?
We don't have any from online.
Okay, any other questions about, yes, sir? Sure.
Like you described, might do something to your son about it. Explain and then send it to you. Set it up. Can you give an example? Would it need to be someone that you should describe earlier? Saying, since we kind of understand the person you want to be making decisions, in that person. For them, that increase, like this kind of, with the house or, you know.
Sure.
Interest bearing accounts that.
Okay, so I'm gonna try to summarize that.
Thank
so
you.
the online-
Thank you. Yes, somebody just asked that. Thank you.
Yes, of course. So the question is, so if the child is gonna end up with the money, however that is. So the first issue is, if you disclaimed or you're not the heir, again, we need to make sure that that inheritance said it was gonna go to the special needs trust, not to the kid. Or we have to do a first party trust, which typically will require court approval. Because that kid will never be the trustee of their own trust, there is always a trustee that is named in the trust documents. Or if there's no named trustee, there better be a process, otherwise you're gonna have to go to court to nominate who the trustee is. So if the special needs trust was set up and it says, my son Joe is gonna be the trustee over my grandchild's trust, if Joe can't do it, Mary is gonna step in. If Mary can't do it, XYZ Bank should serve as trustee. Or the aunts and uncles of the kid get to choose by majority decision who's going to be our trustee of this trust. So the kid is never gonna be their own trustee. It's not a special needs trust if the beneficiary is the trustee. I guarantee you that. In terms of instruction about how the money should be invested, you can do a memo of intent, because I don't know anything about cryptocurrency. I'm very, like, I don't know these things. Like, I've heard the words, right? It may be in the future, we're all trading in cryptocurrency. So if my trust document says all the assets have to be invested in securities that are only traded in the United States of America, and we don't have them anymore, well, that's a problem. In law school, we read about cases where they said the money has to go to a charity that is helpful to allow the settlers to pass through the state of Pennsylvania. Okay, well, I don't think we call ourselves settlers anymore. So if I move to Pennsylvania, am I then entitled to money from the charity? So we want to give broad authority to the trustee because we don't know what the future holds. But you could do a memo of intent that says, I would like for you to continue to use my financial advisor or follow the way I had my assets. I suggest, but I don't require that you follow how my assets were set up previously. Or it's really important to my kid Joe that there's always a light on. Can you make sure that that happens? Or he likes to be really cold. I don't care that it's going to cost more in power because he can't sleep if it's more than 65 degrees in his bed. Whatever memo of intent you want to do. And we also suggest that you keep track of, what's his access number? What benefits is he on? I would say your support coordinator, but they have a tendency to change a lot. So sometimes that's not super helpful. But allergies, likes and dislikes, won't wear long sleeve shirts, doesn't like the color red, wants to always make sure they have a baseball hat on. Like, I don't know what the issues are with your kid, but write it down because you have it all in your head and nobody knows that. So to do the memo of intent, usually I suggest take a notebook and just take notes on what you do and the ups and downs of what happened in a day. Do it for a week. That's probably going to give you a really good picture where you can then summarize it and leave it behind. You can change your mind anytime you want. And then I would disperse it to who your trustee is. Tell the people that you've named in your estate plan, hey, you're the decision maker if the bad thing happens to me. Don't keep that a secret and tell them where they can find the documents. Don't hide them in a lock, in a safe that nobody knows about and nobody knows how to get in. Or you tell them it's at XYZ Bank and there's 4,000 of them in the valley. There's no like central registry for these things. So if you don't trust them enough to tell them where your estate plan is and that they're your decision maker, you have chosen the wrong person because you will be dead or incapacitated when they take over and you won't be able to stand up for yourself anymore. Yes, sir.
I'm just gonna add on to this gentleman's question, but basically the document will say who's in charge, what the money can be used for. And secondarily, that's why it's important to speak with a competent experience. Trust attorney. You get that document created.
Yeah, so that exactly. The trust book is the rule book for how we manage the money, who manages the money, where does the money go? Most special needs trusts are going to have a very broad discretionary standard. They're not going to say health, education, and maintenance and support. They're not going to say they get all the income. They're not going to say they get 25% at age 25, half of what's left and the rest at 35. That's not a special needs trust. And if that happened, they're going to lose their benefits because we have a mandatory distribution that's going to put them over the limit. So that's typically how trusts would work.
We do have a couple of questions online. Are funds a parent puts into a special needs trust impacted by the 5-year look back for Altex?
So the 5-year look back for Altex is a rule that says if you are applying for benefits and you give away money within 5 years of the date of the application, that may lead to a penalty before you are eligible for benefits because you can't have $1 million on Monday and give it all away on Tuesday and say, I'm poor and I need help. Transfers between spouses don't impact eligibility. So one spouse has dementia and one spouse doesn't. We transfer the money over, but when we do the application, we have to disclose all the assets of husband and wife. So it doesn't change what their financial circumstances are, but that's not a transfer. If If the mom or the dad needs to go on Altex, there's an exemption where you can put money in a special needs trust for an incapacitated person without a transfer penalty. If it is a third-party trust, there's no, you have given assets away. Again, there are some exemptions that I don't know all of them off the top of my head, but it's unlikely that that would impact, for example, my eligibility if I had a disabled kid and I'm transferring money to that person, and then I'm gonna go on Altex. There are lots of exceptions.
One more. if I could.
Yeah.
If you want to take,
Okay. You mentioned, trust for your kids. So currently, as it's written, this kid gets half, this other kid gets half, and then we have guardianship, blah, 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 or guardians for the kids. What's the appropriate order of events? We set up the third party trust first and then change on the trust that we currently have.
So the question is, if you've done an estate plan and you realize, you know what, I really need for those shares to go to the special needs trust, you would do them simultaneously. So you would have your trust amended and your new special needs trust drafted, and you would sign everything at the same time typically. Because we need your trust to direct the money, so you have to amend it, otherwise we have a trust and there's no way to get money to it necessarily, because your trust would say it goes 50-50. The other thing about the third party trust is if you have more than one disabled kid and it's okay with you that they don't share equally, you can have one third party trust for more than one of your disabled child, whatever the right term is there. So, but then it's what we call a pot trust. So this kid might have higher needs and they're gonna spend that trust down faster, so there's less money for the other kid. But maybe you don't care because this kid has less needs. If it's a first party trust, it's one trust per person. I mean, you can have more than one first party trust, but you can't have more than one beneficiary in it. And again, in my family, Marissa, so grandma's money, the share for Marissa goes to the Marissa Trust. My husband and I have no kids, the share for Marissa goes to the same Marissa Trust. Her parents' estate plan directs it to that same trust. So it's just for her, but it has lots of sources of funds that would end up for her benefit. Did that answer your question?
It did, but it created another one. So we went to family or will,
Estate plan.
a span, yeah,
Mhm.
but they don't specialize in special needs. So I don't know what, when I go to the estate planning lawyer that we went to, could it be possible that they're gonna say, oh, that's especially because it's outside of my ability, and then want me to take the paperwork, the documentation to the special needs trust to help set up there?
So the question is, I went to a general estate planning attorney and I now know I need a special needs trust. What's that person gonna say? They might do special needs trust. They might say, I'll do the amendment, go see the other attorney so I know what the name of the trust is. So again, for us, we often get called in on cases where somebody's doing something, but they don't do what we do. Just like we call in people to say, I don't do this, I need help at this part. So you would just have to ask that professional. And we must have more than one topic, because we haven't talked about social security benefits. Yes.
so the question was just clarifying, if we set up a third party special needs trust for our child now and have nothing in it, that's okay.
Most special needs trusts are not gonna end up with money until somebody dies, whether that's grandma and grandpa or mom and dad. But you can fund it during your life. You just have to understand it's not your money anymore. So once you put it in, you're short on your mortgage, you can't take that money out again. And once it has 1 penny in it, you have to tell the agencies about it. But most trusts don't get funded during the life of the parent unless they have relatives who are going to money. Sure. So let's talk a little bit about stable accounts. So that's the picture you get when you go to the website. So if you just type in able accounts or stable accounts, I think you end up in West Virginia. So my recommendation is that you open an able account if you're gonna open an account in Arizona, so all citizens really know what they're looking for. And so the purpose of an able account was a way for somebody who's on benefits to save money. It is not perfect because the money in that account, when that beneficiary dies, the state that provided Medicaid services, at least in Arizona, is entitled to the money that's left over in the account when the beneficiary passes away. It's not a substitute for a third-party special needs trust is my point. It works really well for other reasons. You have to tell Altex you created the trust, but they don't get to tell you how to, you created the ABLE account, but they don't get to tell you how to spend the money. So oftentimes when we have a first party trust, the kind that has a budget and requirements and all that stuff, we have them do a stable account too, because for emergencies and other things, they can use that account when we don't have enough time to get approval or where we know Altex is going to say no for what that is. But sometimes those stable accounts are super helpful when there's a small inheritance, a small personal injury settlement. We had a kid who did a scratch off ticket and ended up with like $10,000. So we can't put that in a third party trust and you can't spend it really that fast. And so the money went into the stable account and that was the perfect way to manage it. Other people can contribute, not more than 19,000 in the year of 2025, only one account per person. So if we have divorced people, only one account per beneficiary, not mom and dad get to each set one up. So be conscientious. And the first one that's created is the only one that will be excluded. So if somebody else sets one up, that's a counted resource. So you just want to be careful. They have to be, they're only for people right now who were disabled prior to age 26. Next year, that age goes up to 46. So somebody had a stroke when they were 35, they wouldn't be able to use an ABLE account because they weren't disabled prior to age 26. They can be used for anything that benefits the beneficiary. They're like 529 plans, so the money grows tax-free, comes out of the ABLE account on an income tax-free basis. They talk in the statute about qualified beneficiary expenses. Literally, that's anything. Cell phone bill, clothing, dentist, vacation, TV, whatever. All of those benefit the beneficiary. So the website has like a list, but that's not, you can use it for more than that. I've not met an expense for a beneficiary that doesn't meet the category, the criteria, except giving the money away. You can't gift money and still get the income tax. You then have to pay income tax on the income from the growth of the money. Yes, sir.
That ABLE account.
So the question is the stable account like the person has their own account? The answer is sure, it can be like that. You get a debit card with it, so you can give the debit card to the kiddo. You can load however much money they're gonna need for that month or that week, so they can go out with their friends and have their own card. To get a check, you have to make a request to stable, and it will take somewhere between 5 and 10 days to get the check back to you. So it's not exactly the same, but it can be more, right? Because if the kid's on SSI or DVD Altex, they can't have more than $2,000. They can have up to $100,000 in a stable account, and it doesn't impact their SSI or their DVD Altex benefits. Most of the time, somebody who has a stable account can only manage the little bit of money that's on that card. That's how they got qualified for benefits. But the money on the card, on the debit card, doesn't count against them either, for the most part. So sort of you can use it like a savings account. But because of the payback, you might not necessarily want to fund it all the way to $100,000, and then sadly your kiddo dies unexpectedly, and now the state of Arizona gets whatever that savings was. If the person's working, you can contribute more if they aren't able to contribute to the 401k plan that's at work. They can contribute more money to the ABLE account each year than the $19,000. So again, the money in there isn't counted, so it can be useful. It provides us with some flexibility. In personal injury matters, we use them all the time for the first 19 in the stable account and then the rest in a first party special needs trust or something else. So just be conscientious, and other people can make gifts, as I said, to the account. It just can't ever exceed $100,000, and no more than 19,000 can go in this year. That number changes because it's tied to the gift tax exclusion. There's no brick and mortar for it, so you can't go to Chase Bank and open a stable account. You do them all online. That's how they get set up. And you can roll over a 529 plan. So if you have a kiddo who's not gonna need education and you don't have another kid to give the 529 money for, you can roll it into the stable account so that you can avoid the income tax from any growth that was on that 529. Those are the qualified disability expenses. As I said, it's kind of a short list, but I promise that I can't think of a thing that's not gonna be on there on the list. You can have an ABLE account, you can have a first party trust, and you can have a third party trust. It just totally depends on what the circumstances of the beneficiary are to know what it is that's gonna make the most sense for that person. Okay, SSI and other government benefits. Were there any stable questions?
There were two. So you mentioned 529 accounts, so I don't know if this is the same, but could a Coverdell college account be converted into or rolled into an ABLE account?
So I would have to look it up. If it is a tax, if the money was able to grow tax-free in that account and it's for education, you can probably roll it into the ABLE account. You probably could anyway, if it's after-tax money, because you're basically just taking that contribution that you were gonna spend on those education expenses, and now you're putting in the ABLE account. You just have to watch the limits annually and then total lifetime.
Okay. And then the second question was, do you have to set up the Arizona ABLE account through the Arizona ABLE account website, or could you use another provider like Fidelity for managing the account and funding and investment strategy?
So my understanding is that you have to go to the website, the az-able.com, to set it up. Once you're in that, you have an option, and I think their Vanguard, I think, is the broker that handles that, and they have, you can keep it all in cash, or they have like 4 or 5 different, whatever the strategies are, high income, growth and income. I'm not a financial planner, but there's like 4 or 5, and that's what you choose from. It's not like going to your regular advisor and you're like, I'd like a little of this and a little of that, and let's mix it up. So it's very straightforward as to what. Remember though, you can only have $100,000. So if you're putting in 19,000, you might want to have that all in cash, because it's the idea was to have liquid assets, but you don't have to. You can pick and choose what that's.
Thank you.
Sure. Anything else? You're all still awake. Super excited. An occasional giggle. All right, so government benefits, that'll definitely keep you awake, for sure. So we have 2 different categories. We have kind of means tested and ones that are not means tested. Politicians drive me insane for lots of reasons, regardless of which affiliation you may have. They also constantly talk about things like, they divide it between entitlement programs and not entitlement programs. Well, you're entitled to the program if you meet the eligibility criteria, regardless of which side it is. So we have some benefits like Social Security retirement. We pay into the system. I hope to heaven it's there when I turn the age that I could collect. I worked really hard and I'm on the precipice, so it better be there when it's my turn. But those are retirement benefits, right? So you paid in, other people work, and you get paid from their wages, essentially. You're entitled to those benefits. You paid in and you become disabled. You're entitled to disability benefits if you meet the criteria. But then we have other benefits like SSI, supplemental security income. You are entitled to those benefits if you don't have a work history, you have no income or low income, and you have assets of not more than $2,000, and you are disabled. You are unable to work what's called substantial gainful employment, which is kind of full-time, no accommodations at about minimum wage. You're entitled to SSI benefits. So I don't know what an entitlement program is. If you got it, you were clearly entitled to it. But we have different ones that are based on income and assets versus you did something else already, and so now you're eligible for those benefits. So You can't really do that, can you? Anyway, that's the manual. That's the link for what the manual looks like. And so all text funds D&D. So if you have only a support coordinator, that means that your kiddo did not qualify for all text benefits. They only qualified for DVD benefits because you only got a support coordinator. Otherwise, you're gonna end up with the therapies, day programs, caregivers, group homes, all that other stuff that D&D and all text provide for that person. That has, again, $2,000 asset limit, has an income limit of $29.01 a month. That's gross income before any deductions. So SSI, supplemental security income. There is no reason to apply for this benefit unless you are very poor before your kid literally turns 18 years old. Because if you apply before and you have more than $2,000 in the bank, or you make more than $29.01 a month, they will be denied. Because when they're a kid, your income and assets are deemed available to your child. Once they turn 18, even though they're totally your dependent, you're going to continue to take care of them, your income and assets are not deemed available to the kiddo. So then you can apply for benefits, but otherwise you're going to go through a whole application where you disclose everything you have and everything you make. And then they're going to tell you, thank you very much, not eligible because your income and assets are deemed to that child. If the kiddo works, it will decrease their SSI. If you give them money, that's a dollar for dollar offset after the first $20. So if they were getting, which is really round numbers, $900 a month from SSI, and you give them $20 to go buy a Starbucks, there's no impact. You give them $30, don't care about the 20, but now instead of getting 900, they're going to get $890. So you took away money that the government was giving you, and now you gave it to the kid instead. So I said before, for a special needs trust, it doesn't say you can't give cash, but why would you if the kid's on SSI? All you're doing is they're ending up with the same amount of money. You just took it out of your pocket instead of Uncle Sam's pocket. If you give them a debit card where they can't get cash, there's no impact on SSI. They didn't get cash. So you want to be conscientious about how that's happening. If they work, I don't know who comes up with these cockamamie schemes about deductions, but if they work, the first $85 doesn't count. After that, it's 50 cents off of every dollar. If they make too much money, they're going to lose SSI. They're going to become ineligible and they would probably have to reapply. However, if your kiddo works, there are work trial periods. So you could call and say, we're going to do a work trial period, because lots of kids who have some disabilities are cyclical employees. They get employed for a few months, they get stressed out and anxious, they don't work anymore, then they apply for the next job, and it just keeps going like that, which is not my hope for your kids, but it's something that happens. Then they would stay eligible for SSI even if they're not getting any. And then when they don't have the job, they would get their SSI again. You would say, hey, they're going to try to work, great. However, if they ever exceed what's called substantial gainful employment, they will not be eligible for SSI again because they made too much money previously. So you want to be really conscientious about how much, and you want to make sure if they're working, please, please, please go on that SSA app on your phone and make sure you're entering their wages each and every month. Because if you don't, and they find out later, you're gonna have to pay the money back. If you are on Social Security and you are the representative payee, and there's a payback because you didn't report something, they will take it out of your Social Security. So just be conscientious about what it is that's happening. So to apply, you apply online, and then you will end up with an appointment. So you put in all your information, disability, medications, doctors they've seen, blah, 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 blah. And then you'll get a notice that they're going to do the actual interview on whatever date. And so they're going to ask a bunch of questions about potentially work history, what's going on, how's it going. Then the response to that is either you get an approval, you get a denial, or you get, we need more information. And so if it's a, we need more information, usually they're gonna ask your kiddo to go to one of the Social Security vocational rehab specialists so they can do testing. You know, are they able to focus? Can they complete these tasks? Do we think they're gonna be able to work? For DDD, they're looking for functional ability and cognition. For Social Security, it's about you being able to work without accommodations. So some kids get paid more than they should for the level of work they're doing, or maybe they have more supervision. So somebody's always overseeing what they're doing and somebody else in that position would not do that. But they get more breaks than other kids, or whatever it is. Those are accommodations. So that decreases what their actual income is. The other thing you might get is denied for Social Security disability, when you weren't applying for that. You only get disability benefits if you have enough work orders. But sometimes they'll process the application for SSDI and for SSI. So if you get a denial for Social Security disability, don't freak out. It doesn't mean that you aren't going to get the SSI benefits. They just told you you're not going to get the benefit you weren't going to get to start with. So don't worry about it. So before September 30th of last year, if a trust or a third party paid for food expenses for somebody on SSI, there would be a deduction to the SSI. That rule is gone. Do not worry about paying for food for somebody on SSI. The rule is gone. They changed it. I think the government realized, hey, $967, and they have to meet all of their food, shelter, and all of their other personal needs. And we have tons of food insecurity in this country. So they said, oh, that's okay. We can actually feed people who are on SSI. So you don't have to worry about buying them lunch, or grandma comes to town and she takes them out and buy all the groceries. No impact on SSI. For rent, if your kiddo lives with you, you can charge them rent. If you charge them rent, and you put it in your own account, you can make that account payable on death to the trust, whatever you want to do with it. That will, as long as the amount of rent is more than, I think, $350 a month, they'll get the maximum SSI payment. If not, they're going to get a lesser payment because our lovely government has determined that if you have $967 and you don't have to pay rent, then you should get less. Don't know where they live, but that's what the rule is. Yes, sir.
So this is all, it's all pretty real for me, as my son just moved, like, couldn't buy it.
Happy birthday.
Yeah, and he works a job, like, anywhere from 15 to 25 hours, doesn't make anywhere near the amount. Probably qualifies for something like this, and we were already in a position where we're like, hey, we gotta charge him something, and he's gonna make, he doesn't spend money on anything, so he's gonna make more than 2,000, we're like, go get a new cell phone or something, and go start charging him rent or whatever. So what you're saying here, and maybe I was, if we charge him $350 rent, he'll automatically qualify to get back.
So if he qualifies, so
If he
if they
qualifies.
determine that he meets the medical criteria. The other issue is that when he's working, his SSI will already be decreased.
Mhm.
So we have to do math to figure out
Yeah.
like what's.
So the math would get him something.
Yeah,
But then if we charge him rent, it automatically just becomes the full?
so let's say he wasn't working, let's start there.
Okay.
So if you charged him at least $350 a month, he should get the full $967 or whatever it is. If you don't charge him rent, that amount is decreased by a third, so he'll get like $600 something. If he's working, the first $85 of wages. a
Okay, so
month
it goes
go
back to
down.
that other equation.
Correct, so that's why I'm saying you'd have to look at the math together, but you should charge rent.
Yeah, either way, like it's good to balance the 2,000 versus the society, it's just a.
Yeah. Exactly. And the other use of that stable account is if his account is gonna go over 2,000, even if he's paying you rent, you can move the excess money to
Yeah.
the stable account.
Well, because one of the things we came across is 18, he doesn't have a car yet. And, you literally can't save for a car at all times. Because you just can't, the money doesn't exist without any of his other accounts.
Yeah.
So, and, yeah, so it's like, how do we do this other than just charging rent,
Yep, so you can charge him rent and save up for it. He can put the excess in an able account. That can go up to 100,000 and still be eligible for SSI. So there are different things that can happen with the money in order to get the benefits.
Can I just ask on that as far as like,
saving up for a car and owning a car, he can't have the car, the child can't have the car in their name, correct?
Well, you can own the car doesn't count,
Yeah,
but the
Cars-
money to buy the car counts.
right. So the car is an excluded, a vehicle is an excluded resource.
Oh,
So you can have a vehicle.
okay.
If you use the money from a from a special needs
Hmm.
trust to buy the car needs to be in the kid's name and the trust has to hold a lien against the vehicle. But if the kid's been saving up money, you have money in the ABLE account, they're gonna take it out and go and buy the vehicle, then sure, one vehicle is an excluded resource.
I got it counted towards that $2,000, so.
Yeah,
Every
so
year.
personal possessions don't count, burial fund up to $1,500 of cash value of life insurance. A vehicle, none of that counts towards the $2,000 asset. Yeah. It's super fun. So social security disability. So, yeah, oh, I'm so sorry.
Who's working? Let's say. We can be part of the search, we're looking up. It's. Part-time down. However much it is. Because the amount that mom and dad move. About their ability for the benefits we described.
So the question is, do mom and dad's asset and income impact the kid's ability to get the SSI? Only if the child is under the age of 18. If the child is over 18, the income and the assets of the parent do not impact the SSI. Because they are considered an adult. Oh, sorry.
Yes. Will a child be able to get SSI if they are attending a class at a community college?
So, so again, it's about their ability to be gainfully employed. So you could have a kid who can go to school but cannot keep a job. Anxiety is too high, they're super smart, they get all straight A's. But you put them in an environment where it's do this, do that, there's a lot of noise, a lot of confusion, and they can't be employed, they don't have the ability. They may qualify for SSI, they might not. People also ask me the other thing. If my kid's getting SSI, do I have to be a guardian? Well, guardian is about their ability to make health and housing decisions. SSI is ability to work. I don't know. They might be able to do one and not the other. So they might not get SSI, but be under guardianship. They might not be under guardianship, but getting SSI.
And then a question about charging rent. So if they charge rent, do they have to put the money in a special account or just charge your child rent and his portion goes to mortgage?
So if you're charging rent, you need to collect the rent. It needs to go into your account. So it would go in your account and it's your money. You use part of it for the mortgage, part of it for the groceries, whatever it might be. It's your money to use any way you want to.
Thanks.
So I want to make sure in our last couple minutes that we covered disabled adult child benefits, because I find that people have never heard of it before. So if your kiddo was deemed disabled, and the best evidence of that is SSI recipient under the age of 22, and a parent then becomes disabled and is collecting Social Security disability, starts collecting Social Security retirement, or dies and was eligible for Social Security benefits, the child who's on SSI is going to convert to this adult child benefit. If it's because the parent retired or becomes disabled, they're going to get 50% of mom or dad's Social Security payment without reducing mom or dad's money. And 24 months later, they're going to get Medicare for free forever. And there's no asset limit for this benefit. There is if they're going to stay on all tax, but there isn't for the Social Security benefit. And when the parent dies, they're going to bump up to 75%. So if you wait to do SSI until they turn 30, and then you retire and you collect Social Security and you wanted your kid to get this, you are going to have to prove to Social Security that they were disabled and that they were never what's called that substantial gainful employment. They never got enough money to not be eligible for the benefits, that they earned too much. So please apply for your kids if you think they're going to be eligible when they turn 18. All you can do is get denied. So there's no harm. It's free to do the application. So you should apply And they get denied, they get denied. It's not a problem. But this is a super special benefit. The other thing is if the lower wage earner retires first, and then the higher wage earner retires, they can bump up to the higher wage earners 50% or 75%. They're supposed to link your records together. So if you retired, your kiddo should convert. They don't. So if you call to start your social security, you want to say, I have a kid who's been on SSI since he was 18. And so it's important to me that that person convert to the disabled adult child benefit. And again, on the 25th month, they're going to get Medicare forever and not lose their access benefits. So that access is going to become their supplemental plan to cover deductibles, co-insurance, all of that stuff. So it's a really amazing benefit, and so many people have never heard of it. Yeah,
How does it apply for divorced parents?
they're still parents.
Okay, so
The
it's just
issue would
bumping
be
up.
whether you don't speak to you're the custodial parent and you don't speak to the spouse and you don't know when they're retired. If you have their social security number, you can probably call social security and say, I would like to check if number 1, 2, 3, 4, 5, 6, 7, 8 is collecting anything because I have a kid who would be eligible for those benefits, but they're still their parents. Other questions? You can go home. Thank you all so much. Thank you for having me again. Thank you all for coming and asking fabulous questions.
Where are your offices?
We have an office in Scottsdale and one in Sun City.
At Scottsdale.
Scottsdale, Hayden and,
101.
Pima 101 area. Yeah. Thank you all. Yay.
Thank you so much for your time.